Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, great. So welcome to another episode of Latte with Lawyer. And this is Jonathan Brickman. I'm your host. And today I have Chris Wright. And I'm going to make sure I pronounce the name of your firm correctly. Harris, Wilshire, and Grannis. Is that right?
Yep.
Excellent. Okay, welcome to the show. So just to keep with the theme of the show here, I've got to ask you, what's your favorite morning beverage of choice to get
a black coffee, strong. Sumatra is my favorite. French roast is good. Actually, got some going right now.
Excellent. Wow, it's late in the day and you're already drinking coffee. You told me you drink lots of coffee.
I do.
Yeah, it becomes a habit, doesn't it?
Yep.
Yeah, no, I think when I first got to my first real office job, and I grew up drinking tea in our family, and they didn't have that. It was much easier just to pour the coffee. I got hooked on that too, and now it's like, if there's coffee, I'm drinking it throughout the day.
Well, I used to put cream and sugar in it and stuff like that, but I went to strong black coffee quite a few decades ago.
So you became efficient before your time, right? It's like,
I guess that's right.
Just go straight to the caffeine. Don't dilute it at all. Okay. So it looks like you've got an interesting career. You're working on some pretty high profile things, and you're I don't know much about being an appellate lawyer, so I want to hear about that. And you also do communications law. So tell us about what you do and what your clients look like.
Sure. Well, so, as you say, I'm an appellate lawyer and a communications lawyer, but I thought, if it's okay, I'd start by saying that when I was in law school, I had no idea I wanted to do either. I spent almost 20 years working for the federal government, and most of the rest of the last 21 working for a law firm, Harris, Wilshire Grannis, as you mentioned. But in law school, I also was skeptical that I'd enjoy working for a law firm, and had no idea that doing things for the federal government could be interesting. But anyway, in retrospect, in thinking about it in preparation for this podcast, my career seems to make more sense than it did at the time, and I think it's basically because I tried to figure out what I liked and adjusted as I went along. And so there are kind of 5 segments. I spent 2 years as an appellate law clerk, and sort of liking that, I went as an associate at a law firm for 2 years, mainly because I'd seen a number of lawyers from that firm in action in court, and I thought, well, I could probably learn something about appellate law from them. And then I had the opportunity to go to the Solicitor General's office, and I ended up spending 9 years there because, arguing cases in the Supreme Court is a gas, and it's the one place you can be sure you're doing it. Then by happenstance, I got the opportunity to spend 7 years at the Federal Communications Commission, and I'd only known a little bit about communications law before that, but I thought it was very interesting, and so I took that opportunity. And then really Bush v. Gore came along, and it was time for me to leave the FCC, and my friends Scott Harris, Bill Wilshire, and Mark Grannis had hung out a shingle successfully about 3 years prior to that, and so so I came here.
Oh, interesting.
So that's the overview.
So what does to tell everybody, because I'm not sure everyone knows, but what does an appellate lawyer do versus someone who's not an appellate lawyer?
Right. So we argue cases in the appellate court. So I've argued more than 25 cases in the Supreme Court. I've argued about 25 cases in the DC Circuit, and I've argued close to 20 cases in the other federal courts of appeals, the First Circuit, et cetera. And And so I think everybody knows you have a Supreme Court, and under that you have these different federal courts of appeals, like the DC Circuit and the other circuits. And then under that you have trial courts on the one hand, but you also have federal agencies like the Federal Communications Commission who issue a lot of decisions, and their decisions get challenged immediately in the appellate courts. If you're unhappy with what the FCC does, and somebody almost always is, at least in important cases, thank goodness from my perspective, they file in the Court of Appeals. The DC Circuit hears more cases than any other circuit there, with respect to appeals from agencies. So I've spent a lot of time there over the last few decades now.
Interesting. So I would imagine you probably have something to say about the recent activity with Twitter and Elon Musk. I would imagine that's going to make its way into the appellate courts.
I'd very much welcome the opportunity to be a part of that, because I do think it's a fascinating issue, and there's a provision of the Communications Act, actually Section 230, that plays an important part in sort of protecting platforms from lawsuits, but also giving them an opportunity to moderate their material, and make their own decisions in some ways the way a newspaper or a broadcaster would about what gets carried, but without as much threat of litigation. The theme of Section 230 is to allow as much free expression as possible, and not to make the operator moderate it, but to encourage them to do it.
Right. Well, that is a central issue, right? It's like freedom of speech versus, this private platform that can set their own rules, right?
Yeah. So Section 230 was enacted as part of the 1996 Telecom Act, which I was at the FCC at the time, and so I got a crash course in the new developments, and some parts of the law were terrific and some parts weren't, but I actually think Congress got that right, that you wanted to try to allow as much free speech as possible, without holding the companies liable or having them, sued all the time, but while still giving them the opportunity, the opportunity to kick people off the platform if they're abusing it, just the way a broadcaster could say, I'm not running your show, or a newspaper could say, I'm not running your article. Not sure we found the right balance in practice yet, but we'll see.
Yeah, sure is interesting though. It makes for an interesting debate, that's for sure.
Yep.
Some high profile cases, these young entrepreneurs, Mark Zuckerberg, and now we get Mr. Musk here. Going to be right in the middle of it. I can see you're scratching your head over it, because it's not an easy one. These are certainly tough issues that have a lot of impact on society.
No, and just sort of the art of trying to be an appellate lawyer, and especially in the communications space, is a lot of fun and interesting and challenging, because you have 3 generalist judges on the Court of Appeals hearing your case, and they're very smart and experienced lawyers, but a lot of the cases involve sort of technical issues and sort of background issues about sort of, in that sort of case, how did the problem develop, and what were Congress's goals in adopting Section 230, and how have the lower courts interpreted it? So there's it's a challenge. It's a challenge to get the court to sometimes understand the case, especially when it's even more technical than that. But it's it's fun to try to do that, and of course you have to try to do it in a persuasive way that helps lead the court to the position that what you're arguing for your client is the right way for the court to go.
Right. So your clients are, who are your clients? Give me who you're working for.
Yeah. So our firm, I should say our firm has grown since I started, and we now have energy law and ethics practices and a good trial court practice. But we started with a focus on communications, and we've continued to do an awful lot of that. But it's been a lot of, just a broad group. We do a lot of, we've always done a lot of work for wireless companies, including Sprint and T-Mobile, and we do a lot of work for high-tech companies, and we do a lot of work for some smaller companies. I have a client called Sorensen Communications, which provides a video relay service for deaf people and caption telephone service for hard of hearing people. And I'm sort of proud to have been part of their team now for over a decade.
Interesting.
But maybe if I can give you an example of some of the challenge here. Sort of the last case I've argued really does kind of illustrate some of the things that are in our wheelhouse, but make it hard to make it challenging to be an appellate lawyer in the communications issue. So this was a case that involved Wi-Fi and making more spectrum available for use in Wi-Fi. And my colleagues at the firm, including Paul Margie, helped persuade the FCC to create more opportunity for Wi-Fi. You may know that for decades you've been able to operate at the 2.4 or the 5 gigahertz band, but you probably also know that they've gotten more congested over time. And anyway, in this rulemaking, the FCC decided to make more spectrum available in the 6 gigahertz band, and actually this is now coming online, and there'll be twice as much spectrum available there as in the other bands put together. So I think it's a really a good move by the FCC. But like all important FCC decisions, this was immediately challenged in court by the case called AT&T versus FCC. AT&T is one of the companies that has used the 6 gigahertz band for other purposes, and it said that allowing Wi-Fi use there would cause interference with its transmissions. And so, fortunately, after a couple of decades of work, I sort of understand the technical aspects of this, but it's really an engineering problem. And at the Court of Appeals, you end up with some nice technical issues, and here it was a virtual oral argument, which I've now done a couple, but Judge Tatel was a presiding judge on the panel, and his problem was the following. the FCC had concluded, and as my clients had explained, that the reason one of the key reasons there wouldn't be interference was that while you may perceive your router as sort of being always on and always transmitting, on average, they only transmit 0.4% of the time. And so that fact helps explain why it's very unlikely that there would be harmful interference to companies like AT&T. And as I say, Judge Tatel basically said, well, you know, kind of how could that be? So I, at the oral argument, I said, and I quote, because it appears in the court's opinion, that routers, quote, transmit huge amounts of data in really tiny bursts, unquote. Now that wasn't the most elegant way to say it, but it did the job. It kind of exemplifies how you've kind of got to make, you know, what can be difficult technical issues accessible to generalist judges. And so I'm proud that Judge Tatel quoted me, even if I'm saying that those bursts are really tiny, but you know.
Well, actually, you make a good point there, because you know, most of these things are extremely complicated, and you really have to sort of condense them down to like simple language so people can understand them that don't have the same background. So I agree with you. That's a challenge.
Right. And you know, of course, the judges are very expert on the relevant precedent and administrative practice and that sort of thing. But you always come in, or you should always come in, knowing more about the facts of your case than they do, and should have spent a lot of time with your colleagues and doing moot courts and figuring out, you know, what somebody who's less involved in the case than you thinks about it.
Yeah. So the long and short of it, 6G is going to open up and create more bandwidth for the general public now. That's coming. Right.
So well, there are products on the market. You know, look for that little FCC seal on the back of your router or your Wi-Fi device, and it'll probably tell you. It works on all three bands, but make sure it's got the six gigahertz band too.
So I'll be getting a new router pretty soon from Xfinity, is what you're telling me.
Good. If I could take the opportunity to say a couple words about non-communication stuff we've done at the firm, I'm very proud of our pro bono amicus briefs, of which we filed many, including in the Supreme Court. One set of briefs involved the Obamacare cases, the challenges to the Affordable Care Act, and we had the opportunity to represent Nancy Pelosi and about 20 other Democratic congressmen and senators in the first round. And you know, as you may recall, Chief Justice Roberts sort of cast the critical vote there, upholding the Affordable Care Act, but doing it under the tax clause rather than the commerce clause. And let me say that, like a lot of other people who filed briefs, we did emphasize the commerce clause argument, but after sort of considerable internal discussion, we decided we would advance the tax clause argument ourselves as well. And you know, in retrospect, I'm glad we did. So we also filed a brief in the same-sex marriage case that I think was helpful to the court. So in that case, we represented Professor Laurence Tribe and Professor Mike Dorff, Professor Tribe had developed an argument that was primarily substantive due process with an equal protection twist, is how I think of it. But Professor Tribe had developed this approach, and in some ways it was based on Loving v. Virginia, the case where the Supreme Court had said that there's a constitutional right to interracial marriage. And anyway, the way we approached the case was sort of due process first. Is the right to marry a fundamental right? And Justice Kennedy, writing the court's opinion, did that too and addressed that first and decided it is. And then the second question is sort of the equal protection component. So once you decide something's a fundamental right, is there a reason to deny that right or benefit to the group in question? And Justice Kennedy went along and decided that it was. And so we're very proud that he followed the approach that Professor Tribe had developed, and we'd advanced in our amicus brief to the court.
Interesting stuff. Yeah, I was looking at your background, so I was wondering if you went to Harvard Law School, if he was your professor, but you did not. You went to undergrad there, and you went to Stanford Law School. Is that right?
Right. And let me say, I started by saying I went to law school not really knowing what I was going to do, but I vividly remember Professor Tom Gray describing early in my time at Stanford that describing clerking for Justice Marshall, which he had done just a couple of years before that. And I really, I think as lawyers, we kind of take clerking for granted, but it's really quite a unique thing where people right out of law school, work for these judges who, wield a lot of power, and there's not a whole lot of people in between. I mean, when I was general counsel at the FCC, there were 65 mostly very experienced lawyers on the staff, and here a Court of Appeals judge has 3 young lawyers, and the Chief Justice has 4 relatively young lawyers working for him, and you see the judge or the justice every day, and you work closely with them, and that just sounded like an opportunity that was kind of too good to be true, and that's sort of how I got my foot into the appellate door, because you then see a lot of oral arguments, you read a lot of briefs, and I at least had the reaction that, yeah, gee, I'd like to do that. I think I could try to do that. So like I say, that led me to go to the now to Shea and Gardner, which is now been swallowed by a large firm. But and then because of that, I got the opportunity to go to the Solicitor General's office. And in fact, I wasn't looking for a job, but one of my friends who had clerked for Justice Blackmun at the same time I was clerking had called me up and said he'd taken a job at the SG's office, and gee, there's another opening, encouraged me to apply. So that just seemed like another opportunity, and that as I said, you don't get anywhere else, and so I stayed there for quite a while, just starting a lot of different cases.
Let me ask you. Let me just take you back a little bit. I mean, you mentioned that you were from Bethlehem, Pennsylvania. How did you become a lawyer? How did you get interested in that?
Well, I got to admit, I sort of resisted it for a little while. I have 2 older brothers who are lawyers.
Okay.
Maybe I thought I ought to try something different, and I really wasn't sure from my experience. I did know a few lawyers who worked for Bethlehem Steel, and it didn't sound terribly exciting to me. I was young, but so I actually got a master's degree in educational research and development at Berkeley, and worked there at something called the Teaching Innovation and Evaluation Services, and was hoping to try to make our educational system better than it is, but I changed course and decided to go to law school, and for me that was clearly the right choice, and I'm glad I did it. But I have to say, kind of never had a master plan. I certainly didn't have one that came in involving appellate law or communications law. And to the extent I have any advice to give to younger lawyers, I do think you should realize you can't really know what you're going to do the rest of your career when you start. But if you try different things and see what you like and keep trying to develop some sort of skill, that'll make you useful, then that's the best way to go.
Yeah.
If I can tell an anecdote about communications law, this will upset my son, who's now 32. But so my wife, Becky Troth, is also a lawyer, and she's done a lot of great public interest stuff. But so in 1994, I'm working at the FCC, and Becky is in the Civil Rights Division at the Justice Department. And 4-year-old David walks up to her and says, "Daddy's job is more important than your job because he fixes telephones and televisions." And Becky told me her first impulse was say, "Your dad could fix a telephone or a television, his life depended on it," which would be true. But instead she said, "Well, my job is to try to make sure people are treated fairly." And 4-year-old David said, "Telephones and televisions are more important." Well, it is true that they have a great impact on us.
That's very funny. Well, that's the perspective of a child, right?
Yeah.
And so, is your son a lawyer now?
No, no. He's in the video field.
So no one followed in the footsteps of the parents in law.
Nope. But that's the way it goes. They have to make their own choices, and they're doing well.
Yeah, that's interesting. Yeah, I come from a family of doctors, and nobody wanted to follow that path either. So either go that direction or you totally go the opposite, I suppose. But you're right. I mean, you made a comment about how it didn't seem to make sense, but when you look backwards, it makes sense, which is very true. Everything sort of seems to make sense when you look at it in reverse. When you're going through it, it seems like you have this very crooked path where you're jumping around, but usually you follow your instincts, and right, there's a natural course if you sort of allow it to happen.
Yeah, and look at obviously for me, 3 years in educational evaluator turns out in retrospect not to have made sense. It was a wrong turn, but you have to recognize that too. But I guess I was lucky to figure out that I liked appellate work, and and then I had done a couple of communications cases at the Solicitor General's office, so so I knew a little bit about what I was getting into at the FCC. Although that move was largely involved a lot of happenstance too. So November of '93, I was invited to a bar mitzvah for the son of somebody one of my co-clerks. And also there was Reed Hunt, who had been confirmed as chairman of the FCC the day before. And so it's kind of a Washington thing. We got to talking, and he invited me come over to the FCC, where, among other people, I met Bill Kennard, who Reed had already hired as general counsel, and who knew a lot about communications law, but had relatively little appellate experience. So I had something to offer, and I ended up coming in as a deputy general counsel, focusing on the appellate stuff. And, as I mentioned, the 1996 Telecom Act got passed, and that gave everybody a crash course in new law. And Reed left in 97, and Bill became chairman and was kind enough to make me general counsel, even though I had basically no political clout or anything. But so that was a very nice thing he did for me.
Yeah, interesting stuff. So let me ask you a question. Given the explosion, I'll say, of technology in the legal space, what's your view on that? And does your firm use any legal tech platforms to help your practice? And do you embrace it?
So my colleagues embrace it. At the trial level, we have all kinds of stuff. And given my practice, I don't really know much about it, but I learned a bit by osmosis about all the things the new technology can do when you're trying to search documents and doing other things. And I know you do some interesting work, focused more on trial courts. It has occurred to me that sort of our old-fashioned practice of doing moot courts before appellate cases is a bit like what you do. Although I don't know of anybody who's tried to involve technology in that. But I co-teach the DC Bar's CLE course on oral arguments, and I always encourage people to do moot courts, but I especially urge them to do it using lawyers who are more like the judges, that were not immersed in the case, who are not sold on their position, and come in sort of more fresh, and get their take on the case, and then reshape your argument with what you can learn from them. So well, I guess this is old-fashioned technology, but actually, when Ken Starr was Solicitor General and John Roberts was Deputy Solicitor General, when I was in the Solicitor General's office, Ken had been a Court of Appeals judge, and he definitely believed that oral argument was more important than lawyers sometimes thought. And anyway, he bought us video equipment and encouraged us all to videotape our oral arguments and look at them closely. And I did that, and I can't say I do that too often anymore, but it was it was somewhat painful experience to watch yourself and listen to yourself, and I hope can learn some things about it. I got criticized in a DC Circuit case once by a judge for smiling too much and then for frowning. It was kind of strange, but I was not at the podium. I was watching my opponent, and and I guess I was sort of, while I was smiling, according to the judge, he stopped smiling. So then I tried very hard not to smile, well, stop frowning. Anyway, we won the case, so it didn't necessarily matter.
That's pretty funny. I mean, that is interesting. I mean, I guess the judges do have a lot of power, and they can really sort of control the mood, right, of the courtroom.
Yeah, so in the appellate court, of course, though, there's always more than one judge. I don't know whether that makes them sort of less likely than trial judges to feel like they're in control. But of course, they're in control compared to you.
Right.
And I've almost always had excellent experiences. Judges might sometimes be too conservative for my taste or whatever, but they're always they're always trying to understand the case and do the best job they can to figure it out and write an opinion that makes sense. Like I say, they may come in with certain preconceptions that sort of push them one way or another, but they're really not up there to give you a hard time or whatever. I guess I also advise when I teach my oral argument class that one of the best things you can do is to actually do moot courts for other lawyers and think about them as if you're actually a judge and have to cast a vote shortly after the oral argument, which is how it generally works. The Court of Appeals judges hear a bunch of arguments and they go back into what they call the conference and they vote and they've signed the opinion, and sometimes that changes, but most of the time it doesn't change. And so, the last thing they hear about the case before they decide it is listen to you and read your briefs. And so I sort of say, if you're pretending that you're actually a judge as opposed to somebody who's got to give the person a hard time, I constantly get annoyed by these briefs where people seem to be trying to hide the ball rather than clearly tell me what's going on, for better or worse. And similarly, when you're doing your moot court, well, why won't the person just give yes or no answers to the extent they possibly can, or at least say yes, but, or yes, if I understand this. And if I ask a hypothetical case, I don't need to be told that that's not this case because it's a hypothetical.
Right.
But please answer it. If you can't answer my hypothetical in a sensible way, that suggests that your position doesn't make sense. It is just crafted to win this case. And anyway, I think that if you sort of think, if you do the moots that way, it helps reinforce the idea of being concise and straightforward, both in your briefing and in your oral arguments.
Yeah. Well, this is certainly not meant to be any kind of promotion for what we're doing, but that's the whole thrust of the piece of software that we have, right? Is to gather these authentic insights, right? So it's not biased anyway. There's a lot of bias, right, when what you were describing. And the whole purpose of whether you're doing a moot court or moot trial or a focus group or just in front of something, you want to get a real authentic, unfiltered response, so if what you're presenting actually is resonating the way you want it to, right? And that's hard to do when you're relying on humans to.
Yeah, and look, I think it's a lot easier to have insight into what appellate judges are likely to be thinking than it is
right
about a cross sample of humanity.
Yes.
So
exactly.
So your work's needed.
So, anyway. All right. Well, listen, on that note, we'll wrap this up. This has been really interesting. You certainly educated me quite a bit. And it sounds like you're doing some really good work, and that's great to hear. But if someone wants to reach you, what's the best way to get in touch with you?
Well, like all lawyers, we have a website, Harris, Wilshire, and Grannis, hwglaw.com. And you can find me there. You can find my phone number. You can find my email address, cwright@hwglaw.com. And so thanks for the opportunity.
Absolutely. See, you're using technology. You just said, look at the website. There you go.
Good.
All right. Well, listen, thanks again. This has been Chris Wright with, and again, I'm going to struggle to say it again, but Wilshire, let's see,
Harris,
Wilshire
Wilshire.
Grannis. Okay, HWG, which is why you
Right.
have it on your website. And this has been sponsored by EmotionTrac, and we use artificial intelligence to gather nonverbal communication insights used for mediation and trials. Thank you very much again, Chris. Appreciate it.
Thank you.